Good afternoon and good morning to our West Coast listeners. My name is Juan Thomas, and I have the honor of serving as chair of the ABA Civil Rights and Social Justice section for the 2022-23 bar year. And I want to welcome two distinguished guests that we have today, Mr. Steve Wermiel and Mr. Frank LoMonte. Steve is a professor of the practice of law, constitutional law, at the American University Washington College of Law. And in 2012-2013, he served as chair of our Civil Rights and Social Justice section. He's been an active member of the American Bar Association for many years, as a member of the Board of Governors, of the House of Delegates. He's also a former Father Drinan Award recipient. Steve, welcome. We're glad to have you.
Thank you. Glad to be here.
And Frank is the former director of the Bechner Center of the Freedom of Information at the University of Florida, and he's currently the counsel for CNN. And in a previous life, he was an investigative journalist as well. And so we're glad to have Frank here as well.
Thanks so much for the invitation.
Great. Well, gentlemen, you both know that we are currently witnessing this week and hearing Supreme Court cases involving free speech and free press. That's our subject for today. And I want to start with Steve by asking you for historical perspective on this issue, particularly in light of the New York Times versus Sullivan decision from 1964 and the implications of that decision on free speech and defamation cases as we consider what's going on today.
Thanks, Juan. And again, glad to be here and thank you for your service as chair. I remember my time fondly, and it's a challenge, but it's great work. Yes, we shouldn't be talking about New York Times against Sullivan. It should be settled and there should be no controversy about it, and something that we don't need to really revisit. But that's not the case. Two Supreme Court justices, Clarence Thomas and Neil Gorsuch, have suggested that it ought to be overruled. We don't know whether there are other justices who may be prepared to join them in some case in the near future. And so we do need to talk about New York Times against Sullivan. The history, it's a 1964 decision that is very much a product of the civil rights era. In short terms, Southern judges, Southern political leaders were using their state libel laws. This was an Alabama case, but it was happening in other states as well. They were essentially using their libel laws to try to drive Northern media out of the South and make it impossible for them to cover the civil rights era. Remember the images of the dogs and the hoses attacking the civil rights protesters, and that's all being displayed on the evening news. They wanted none of that. They wanted the New York Times and the Atlanta Journal-Constitution and NBC to go home. And so they were trying to make it too expensive for them to be able to stay and do their job. And the Supreme Court rose to the occasion and basically said, we have a long history of believing that free speech is the cornerstone of our democracy, and protecting the ability to criticize our leaders, even when it may be libelous, even when you may harm somebody's reputation, being able to comment freely and debate freely is the touchstone of our democracy. And so that's carried us through the next 60 years. Lots of controversy. The plaintiffs think they can't vindicate their reputation. The media think it's too expensive to have to defend against libel suits. And so there have been various periods where nobody really liked the decision, but the media has never given up on the fact that it is a critical protection for the ability of the media to do their job. And that's still where we are today.
And so there was a Supreme Court case that they argued yesterday. There's another one today that I believe that just concluded arguments. Frank, could you connect the history of what came out of the Sullivan decision with what's going on today in the context of the social media platform that we are all living with?
I'll try. I will start, by the way, with a little disclaimer that I need to issue that whenever I speak in a venue like this, I'm speaking on my own and not on behalf of my employer, even though I have my CNN cap and my CNN coffee mug with me. But so I'm on my own nickel today. But on my own nickel as an
This is not
individual
CNN
observer,
reporting today, right?
as an individual observer of this and a sometimes scholar of it. Yeah, I had the opportunity to watch both or listen to both oral arguments today. And, when you talk about freedom of speech, freedom of expression today, invariably that's going to implicate the internet and in particular social media, right? As Steve was explaining, the rules surrounding kind of print publication have been established for many years now, but we're still in kind of the wild, wild west, that first generation of cases as it regards online speech. The Supreme Court, by my count, has taken a grand total of 4 internet speech cases in the entire history of the internet so far, and not counting the ones that were just argued, but they've decided 4. And by the way, speakers are 4-0 in those cases, interestingly enough. So the court has been highly protective of the right to speak online, and they've resisted apportioning by people to lower the threshold for liability for online speech. They've resisted the idea that because the internet somehow is more pervasive, more durable than other forms of speech, that it should get diminished protection. They've said over and over again, I think most memorably in the ACLU Janet Reno case, that speech is speech is speech is speech, no matter what medium it carries on. And so Facebook gets exactly the same amount of protection as the New York Times, no more and no less. But up against that backdrop, today's cases, yesterday's and today's, were believed by a lot of people, I think, to be a vehicle by which the court could revisit what Congress decided in 1996 in passing what's called the Communications Decency Act, for short, Section 230, right? And
Right.
Section 230 of the CDA is what enables companies like Facebook and Twitter and Instagram and YouTube to stay in business, frankly, because it is a blanket grant of immunity for tort claims arising out of the speech of third parties who use a platform that operates interactively. So you're any kind of a website that has any kind of user interface to it, you can always be held liable for your own speech, but not for the speech of those outside third parties who come and hang a comment on your comment board. And that's the only way, frankly, that the business model of social media could even work, right? Because of the velocity of posts that are streaming through their platform. But many people are dissatisfied with the consequences of that blanket grant of liability. The dissatisfaction is equally, in equal measures on the left and on the right. During the last campaign, both Donald Trump and Joe Biden called for repealing Section 230, one of the only things they agreed upon, even though there's been no actual congressional movement to do so, because nobody can agree on what a fix looks like. It's kind of like the Churchill quote about democracy. It's the worst possible system of government except for all the others. Section 230 is the worst possible way to govern the internet, except for all the other ways. And so not being able to pass anything in Congress, advocates have turned to the Supreme Court, hoping that maybe they'll roll back the protection of Section 230 and open up some liability claims. And this pair of cases involves one against YouTube, one against Twitter, involves the Material Support for Terrorism Act and people who were victimized by terrorist violence, trying to say that both YouTube and Twitter should be held responsible for having provided a vehicle by which terrorists could become radicalized. So in other words, they were the on-ramp for people to become exposed to speech that then radicalized them in a way that the advocates would argue constitutes material support for terrorism. And I would say if you came into those cases hoping that this was going to be the vehicle for overhauling Section 230, I strongly suspect that you will leave disappointed, because I did not sense that either on the left or the right side of the bench that there was an appetite for using these cases as that vehicle. And that if I had to prognosticate, the Twitter case seems quite firmly rooted in just a statutory construction argument. There were an hour and a half of oral arguments today in which Section 230 wasn't even referenced. It was entirely a matter of statutory construction. And I think it's possible, surely the Twitter case, I think even in the YouTube case, it's quite possible they could have decided on a very narrow statutory construction basis without touching the Section 230 issue much at all, and certainly without granting kind of that broad rewrite by court fiat that a lot of the advocates were rooting for.
So in the context of, you mentioned Section 230, there's language that talks about malice or knowingly publishing false information. Do you see that as a concern of the court now? And to what extent do you believe that internet companies like Facebook or YouTube or Twitter should be mindful of knowingly putting forth information that may be false or having malice intent? Is there any way could you comment on that?
Well, it's a great question, because I do think, right, this is where advocates on the left side of the political spectrum in particular think that Section 230 is going too far, right? That it emboldens people to engage in kind of very low value trolling behavior, to promulgate things that they know are, conspiracy theories, sometimes theories that are very directly aimed at destabilizing or delegitimizing elections. And this is where the First Amendment comes into play in a very interesting way, because even though we think of the First Amendment typically as being the right of individual speakers, in this case, where the First Amendment comes on stage is as the right of the platforms, right? And we're really going to see this front and center. I think these cases, the Twitter case and the YouTube case, were the appetizer course, but the entree course is yet to come. There are a pair of cases, one out of Texas, one out of Florida, called the net choice cases, and those directly tee up Section 230 because they involve state legislatures trying to tell these platforms, we are going to hold you responsible for the choices that you make in terms of what speech you take down, what speech you leave up, what speakers you allow onto your platforms or disallow on your platforms. And so this is really a headlong run at Section 230 by these state legislatures. And both the Fifth Circuit and the 11th Circuit ended up on First Amendment grounds in joining key provisions of those statutes. The briefing is almost complete, and so we could see a decision on cert any day now. But should the Supreme Court take that, then the First Amendment argument will be on behalf of the publishers, saying, as a platform host, right? And the Supreme Court has a famous case called the Pat Tornillo case out of Miami involving old school platforms, involving the Miami Herald, where the Supreme Court said, well, no, we can't, under the First Amendment, override the publisher's editorial discretion and compel them to publish something that that their editors disagree with. And so that precedent is still there. And I think if you take the Supreme Court at its word that publishing is publishing is publishing is publishing, and that Twitter and Facebook and YouTube have no less First Amendment right than the Miami Herald does, that the pathway is pretty clear, unless there are 5 votes to deviate from Tornillo.
Right. Steve, thank you for that, Frank. Steve, you are a expert in Supreme Court. You've written extensively on the history of several Supreme Court justices, and you follow the court extensively. What is your sense of the current makeup of the court and how they may look at Section 230 and just issue more broadly around free speech?
Well, I think, Frank's done a great job of covering the Section 230 issues, although I will just say, I think we're going to have to wait a little bit longer for the Florida and Texas cases, because the court asked for the Justice Department to weigh in, and that may take several months before we see the Justice Department's position. But I think more broadly, interestingly, this conservative court is at times very supportive of free speech. There's some places in which they've narrowed the protection for speech, but there are quite a number where there have been efforts to try to take an entire category of speech, violent video games or videos of cruelty to animals, and the court's been asked to put those totally beyond any First Amendment protection. And the court has said, no, we're not interested in creating entire new categories of speech that is outside the scope of the First Amendment. And so I think this is a court that for various reasons, maybe because they don't like political correctness, maybe because they think conservatives are the victims of restrictions on speech nowadays, but they've been supportive of a variety of free speech issues. One of the interesting things that I think is happening, and it's not a brand new trend, but it's an accelerating trend, is that they're now saying that religious speech has to be protected in the same way that other kinds of speech is protected. And governments used to be able to say, I know we're getting into religion here and it's not our mandate, but governments used to be able to say that because of the Establishment Clause, they could treat speech about religion differently.
Right.
And the Supreme Court has pretty much totally done away with that concept and pretty much done away with the Establishment Clause, frankly. But more significantly, in a couple of cases last term, they made clear that if you're treating the speech differently because it's religious speech, that's content discrimination in violation of the Free Speech Clause. And that's kind of a new, or as I said, accelerating concept. And I think a very important one to watch to see how far they're going to go with that.
Do either one of you believe, and I'm thinking about, the millions of people that make comments on social media platforms, either in the like or comment section on Twitter or Facebook, do these cases have any implication on just individual people that may respond to a Twitter post or a Facebook post, or is it really more about the platform itself?
I mean, Frank has looked at the cases yesterday and today more carefully than I have, but there is discussion in yesterday's case about the fact that the statute includes users, not just platforms. Section 230, at least in theory, is supposed to provide immunity to users of the platforms. And people don't focus on that very much. I assume if I post something on Facebook that libels you, Juan, that Facebook couldn't be sued, but I probably could be. But exactly how the reference to users in the statute plays out, I think, is something we really don't know.
Yeah, but just to add to that, right? I mean, where that could come into play would be something like the retweet function on a platform, right? If Steve, instead of posting his own post on Facebook, retweets a Washington Post article in which you are defamed, he doesn't add any of his own content to it. He just brings it to the attention of his followers, and that article proves to be defamatory, right? In the absence of 230, it's at least conceivable that the plaintiff, having then prevailed against the Washington Post, could go and track down each and every sharer online and say, you republished libel, right? Which in print in the old school media, republishing libel gives you ownership of the defamation, but 230 insulates you against sort of what we could call retweet liability. So yeah, if that were torn down to the ground, then I think people would understandably be much more hesitant to use the platform.
Exactly. Is there current ABA policy on this issue around free speech, or if not, should there be? And what can lawyers in the ABA, but also just more broadly, do to be more knowledgeable of these issues and be more informed?
Well, Steve is the scholar on the Board of Governors, so I'm going to defer to him on what the current policy is.
I apologize. I don't know if the ABA has adopted specific policy. I think the ABA has adopted policy basically supporting a broad use of the internet. I don't know if they specifically have addressed the scope of Section 230, and probably should, although at this point may want to wait and see, what happens with this set of cases, and as Frank said, with the Florida and Texas cases as well. I will say, I think the ABA as a general proposition could do more to support free speech rights. We're living in a divisive period in which supporting a broad vision of free speech is sometimes understood by people to mean that you are willing to tolerate various forms of offensive speech or speech targeted at particular groups, and that issue divides the legal community as well as the broader community very deeply. I have sometimes felt that the ABA could do more to support the original kind of marketplace of ideas theory. Not that
Right,
we want you to use speech to be insulting to other people, but that those people have the power to speak back and negate the effect of the insulting speech. And that's part of the premise of New York Times Against Sullivan, and it's part of the
right,
premise of our whole democratic approach to free speech. But I think it's under attack. I think partly political correct. I mean, conservatives think they're being censored too much, and liberals think they're being exposed to too much offensive speech. And so it leaves free speech kind of sitting in the middle, but vulnerable from both ends.
right, right.
To that, if I could add, we have
Please.
social justice in the name of our section, and I think people who have social justice in their hearts are understandably very tempted in today's environment to relax their vigilance about freedom of speech and to elevate other values ahead of their adherence to freedom of speech. Look, I don't like people being harassed. I don't like people being trolled. I don't like people being doxxed. And none of us likes those things. The problem is always, if you're prepared to relax the First Amendment and to recognize that new categories of speech are going to be constitutionally unprotected, then you have to be prepared to see people in handcuffs going to prison for that speech. And I think two things there. First of all, one could ask whether it's consistent with a social justice focus to be putting lots more people in prison. But also, you have to always engage in that thought exercise of envisioning that the most extreme member of the party that you oppose is in the White House, appointing the attorney general and all of the U.S. attorneys in America. And are you comfortable equipping that person with new tools to go after speakers? And if the answer is no, then you ought not relax your First Amendment vigilance, because after all, that is a door that swings both ways. And while today people that you like might use it to go after the people that you do not like, we know that that pendulum can swing in dangerous ways tomorrow.
Are there, I think that's a very important point I think people should be mindful of. Are there resources that you would point to for lawyers or other people interested in free speech issues to read or refer to, websites or books that you would suggest?
I've heard there's this really good book called Justice Brennan, Liberal Champion. I don't know that much about it, but
you know the author?
yeah, I think he's in that box right beneath me.
Right.
But I've heard that's great.
And
I'll
I owe you one, Frank.
I'll put in a plug for one other one that I just love and that's been very influential to me, and that's a book called The Race Beat, B-E-A-T, by Gene Roberts and Hank Klibanoff, and it really makes the connection in a very dramatic and meaningful way between the success of the civil rights movement and a free and uncensored press. And it has this just indelible quote from John Lewis that concludes the book. I'm going to spoil the ending, but it's a great one, where Lewis says, the civil rights movement without the press would have been like a bird without a song. And so it really helps you appreciate that while we may think of the First Amendment today as a vehicle behind which Klansmen and purveyors of hate speech hide, that in fact the First Amendment is why Bobby Kennedy and Lyndon Johnson became sensitized to the existence of violence against civil rights protesters and couldn't ignore it.
Right. Great resources, great information. Steve?
And those two guys were incredible pioneers. I mean, Hank Klibanoff, did some of and Gene Roberts too, did some of the greatest reporting on the civil rights movement, and sometimes at risk of their lives and personal safety, and so they're a great example of the value of a protected free press.
Exactly. And speaking of good books to read, I want to just conclude by asking you both, what book are you reading now, or what's the last book you read?
I mean, I'll jump in. The last one that I read, I didn't read cover to cover, but I read much of it, is by I think a friend of Frank's as well as mine, a lawyer named Bob Korn Revere, who's a First Amendment kind of absolutist, and he wrote a book called The Mind of the Censor and the Eye of the Beholder. And what I think is most interesting about it is it tells the story of a man named Anthony Comstock, who was a postal inspector in the late 1800s, who's responsible for all of our obscenity laws and anti-pornography laws. And I mean, ironically, part of the debate, I know I'm going way off topic, but part of the debate over whether you can mail the abortion drugs through the mail today after Dobbs goes back to a Comstock law that said you couldn't send in the mails anything related to abortion or contraception from the 1880s or 1890s. So it's a very interesting story, and I recommend it.
Frank, what about you?
Well, based on our picture, Steve obviously owns a lot more books than I do. But like Steve, I'm going to be very boring and on brand here because my nightstand consists entirely of nonfiction books about free speech and the First Amendment. So I just finished Amy Edmondson's book called In Sullivan's Shadow that is exactly about the topic we started with, the impact of New York Times v. Sullivan. And it specifically focuses on how libel law was long used as a tool for harassment of pro-civil rights journalists in the South, and how it's important that we have these what are called anti-SLAPP laws to enable people who are targeted for harassment by way of frivolous libel suits to be able to get an off-ramp to get those dismissed and get their attorney fees back at the earliest opportunity. So plug for that book. And I just last night cracked open Jeff Kosseff's book called The United States of Anonymous. That's all about the importance of anonymity to the ability to exercise free speech rights. And Jeff is the leading expert on Section 230. His book has been very influential and got a shout out in yesterday's oral arguments. And so definitely recommend his work to anyone interested in this area.
Well, that's great. We'll be sure to pick all those books up and make sure people on our YouTube channel get those as references. So I want to thank you both, Steve Wermiel and Frank Monte, for being our guests today, two leading experts on free speech and free press. We appreciate your service, your expertise to our profession and to the bar. And thank you all for listening. Look forward to seeing you all next week.